Alright, everybody. Hello and welcome to Section 4 of Introduction to Criminal Justice. I know you're all excited to be here, and we are going to talk today about law. Not Judge Dredd, who is the law, but actual American law. So, first, we got our funny picture of the section. Like that old joke where the officer goes up to, pulls a guy over, walks up to the window and says, "How high are you?" And the guy says, "No, officer, it's high. How are you?" Yeah? Alright, it's funny. Alright, so, federal law. Where does federal law come from? Well, contrary to popular belief, there are lots of different sources for federal law. The first and most obvious being the U.S. Constitution. Okay? The U.S. Constitution was first passed in 1780-something. I don't even remember. But it's actually a very, very short document. If you've ever gotten a copy of the U.S. Constitution and sat down and read it, it's actually really, really short. But then at the end of the main body of the Constitution, you have 27 amendments. And those amendments are what most people think of when they think of the Constitution. And there's a lot of different amendments that provide different rights to the people, and they change how the Constitution has been interpreted over the years. So, for instance, senators, U.S. senators, did not used to be elected by the people. They were elected by the, I think, state legislatures. But there was one of the constitutional amendments, and I can't remember which one, that changed the way U.S. senators were elected, so that now we vote for them directly as citizens. So the Constitution is a source of federal law, and there is actually one criminal law in the Constitution. Anybody know what it is? Anybody? It is treason. So the law against treason, and the penalty for such, which is the death penalty, is actually a criminal law outlined in the Constitution itself. Now, in the 200 plus years of the Constitution having been ratified and existing as federal law, you know how many people have been tried and convicted of a violation of the constitutional treason law? 0. Not a single person has ever been tried and convicted in the United States of the treason law in the United States Constitution. But it is there, it does exist. The other main source of federal law is legislation passed by the legislative branch of the federal government, right? It's split up into the U.S. House and the U.S. Senate, and any law that's passed has to start in one, get passed in that one, then go to the other, get passed in that one, and then it goes to the president for either a signature or a veto. And the president can say, nope, I don't want this to become a law, and he can veto it. But then the legislature can go back and say, no, we want to override your veto. And if it passes by a 2/3 vote, it becomes law anyway, even over the president's veto. Another place that we get federal law from is executive orders. And executive orders have been around since George Washington. They've always been there, and presidents have used them since George Washington to kind of add to and clarify executive policy and executive branch, anything that the executive branch has kind of control and oversight over. So things like immigration, things like the military, what businesses the federal government does business with, things like that. The president has fairly wide power to pass these executive orders saying, look, this is how we're going to do things from now on. And those are a piece of federal law and have the force of law within the United States. Next place that we get law from is judicial decisions. There's a thing called stare decisis. Okay, it's a legal concept that basically says we are going to do what previous courts have done outside of very extreme circumstances. Okay, it's also known as precedent. Okay, courts do what previous courts have done, and it takes a fairly big thing for a court to overrule or overturn what a previous court has done. Okay? But judicial decisions have the force of law. So, for instance, the Miranda laws that we talked about in Section 1, that is it is legally required for police to read suspects their Miranda rights before they interrogate them. Okay, that is a legal requirement, and it came from a judicial decision, namely the Miranda v. Arizona decision. And then finally, we have international treaties. International treaties also have the force of law within the United States, but these are very, very complicated, and there's a gazillion of them, and each, if we have an international treaty with one country, we might have a similar international treaty with another country, but it's not going to be exactly the same. So, for instance, we have extradition treaties with almost all of the other countries on the planet, right? And an extradition treaty basically says if one of our criminals is in your country, but we want him to come here either to face trial or to face punishment or whatever, you will arrest him and send him to us, and the other way around, right? So if a French criminal commits a murder in France and then flees to the United States, we will arrest him and send him back to France so he can face trial and punishment. These are different with each country. So our extradition treaty with France is going to be different than our extradition treaty with Brazil, which is going to be different than our extradition treaty with China, right? They're all different, and they all have slightly different methods and, fine print, if you will. So those get real complicated real fast. But there are lots of these international treaties that have the force of law. So how a bill passes, we talked a little bit about that when I talked about the legislative section, right? But this is something you need to know, because it's important to know if we're going to enforce the law in the criminal justice system, we need to know how those laws are made, right? So the basics, there's the House and the Senate. They have to pass by a 50% plus one of both chambers. Then it goes to the president to either sign or veto, and if it vetoes, they can override that. Most states have a very similar system for state law. The vast majority of states have two chambers, just like the U.S. federal government. There's a few states that only have a one-chambered legislative body, but most of them have two, and then it goes to the governor to either sign or veto. Some states have what's called a line item veto, where they can veto just parts of a bill and not the whole thing. But it's important to know that, okay? Most of this federal law that passes is civil law. Okay, it's not criminal law. There are comparatively very, very few criminal laws when you look at the entirety of, what makes up the law. There's very, very small part of it is criminal. But civil law is everything from taxes to inheritance to divorces to how you have to register a boat to if you're going to serve at a restaurant, what kind of safety precautions do you have to make sure people don't get sick, right? That is all civil law. Criminal law is a very specialized subset, but obviously since this is a criminal justice course, we are going to be focusing mostly on the criminal law, although we will talk a little bit about civil law, okay? So, when we talk about criminal law, how do we split it up? Well, traditionally, the big split in law, like in human history and in legal history, going back to the Babylonians, has been, they use these Latin phrases to describe it. There's mala prohibita and mala in se. Okay? Mala prohibita means evil because it's prohibited. Mala in se means evil in itself, right? Today, we call those felonies and misdemeanors. Felonies are the mala in se. They're evil in themselves. Basically, what constitute felonies in the United States are going to be felonies all over the world, right? Because every culture, every people group in the world throughout time have basically agreed that these are bad things, right? Murder, rape, robbery, arson, burglary, auto theft, right? So all of those things are pretty universally understood as evil. Whereas the misdemeanors or the mala prohibita are, in general, the minor things that are might be illegal in some places but not in others, like parking violations and speeding and things like that, right? Like low-level illegal gambling, that kind of stuff. Okay, the divide in the United States, well, in 49 out of 50 states, the divide between a felony and a misdemeanor is that a felony is a crime which can get you 1 year or more in prison. A misdemeanor is a crime that will get you under a year in a jail. Okay? The one state that doesn't apply to is Texas. And in Texas, it's a 2-year limit. So a felony is 2 years and above. Misdemeanor is under 2 years. Okay? Rules for laws. There actually has to be a set of rules that are followed any time that any legislature at any level of government wants to make a law. The first is they have to be public. If you expect people to abide by a law, you have to make them public. You cannot have some law that you're going to punish people for breaking if they don't at least have the opportunity to look it up and read it. Okay? Second thing is ex post facto. That's fancy Latin because lawyers always have to make fancy Latin terms for everything because they're lawyers and they want to be in this secret club where only they speak the Latin and know the language. But ex post facto basically means you can't have a law that criminalizes something before the law was passed. Okay? So I've got my Monster Energy drink this week. Let's say tomorrow the U.S. government passes a law that says drinking Monster Energy drinks is illegal. They could not then use this recording to arrest and try and convict me for breaking that law because I broke that law before it was a law, right? So you can't try and convict people for breaking a law that wasn't a law when they did the thing. So you can only punish people for breaking that law after the law was passed. That's what an ex post facto law would be, one that didn't follow that. So rules for laws, it should say no ex post facto, right? All laws must have due process. And there's both substantive due process and procedural due process, which is a very complicated thing. If you want to learn more about due process and exactly what the difference is between substantive and due process and procedural due process, go to law school, which I highly recommend because law school looks like it'd be really fun. I never actually went to law school myself. I got the PhD instead, but what are you going to do? But substantive due process is essentially, does the public have an interest in making it illegal? Is there a public interest in making drinking Monster illegal? God, I hope not, because these things are delicious. But there also must be procedural due process, meaning the rules must be followed. Okay? And again, it's really complicated how those two work together to make sure that due process is followed. But you can go to law school if you want to learn more. So laws also have to follow the rules of evidence, right? So we have rules of evidence for a courtroom about what can be introduced into evidence, how they must be collected, how it must be stored, how it must be presented, how it must be authenticated, all those things. No law is allowed to violate those rules of evidence. It can't be vague or overbroad. Okay? You can't just say killing people is illegal. That is overbroad, right? Because there are situations in which killing people is legal, right? The most obvious being self-defense. Your law has to be specific so that it doesn't make illegal things like self-defense. Also, killing somebody during a war, right? That's obviously not illegal. If they're on a battlefield in uniform, we kind of pay the soldiers to kill them. So we need to make sure the laws aren't too overbroad or too vague. They also must respect the right to privacy, right? The Supreme Court has ruled that between the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, all these things kind of combine to say, like, Americans have a right to privacy. In other words, the United States government cannot violate the privacy of an American citizen without very good reason. Okay? So it can't violate that rule. And finally, if it's a criminal law, it has to have a specific legal punishment to be followed if somebody breaks that law. Now, the vast majority of the time, I would go so far as to say basically all of the time, there are pre-existing categories for every level of government, and whenever you make a new criminal law, you just have to attach it to one of those pre-existing punishment categories. Okay, so like in a state, they might have A-level misdemeanor, B-level misdemeanor, and C-level misdemeanor. And C-level misdemeanors, like no prison time, maximum penalties of fine. A-level misdemeanors, it's like up to a year, and then B-levels in between. And then if you go over into felonies, there's like class 1, class 2, class 3 felonies, and then capital felonies, right? So there are these different pre-existing punishment categories, and then every time you write a new criminal law, you just say, okay, we're going to make this illegal now, and it's going to be a class B misdemeanor or a class 2 felony, right? And you can kind of just attach them to those pre-existing punishment categories. Make sense? Good. What do we have to have in order to have a crime? Okay, well, again, going back to lawyer Latin, because lawyers love Latin, you have to have, in most cases, two things. The actus reus and the mens rea. And again, these get real complicated real quick, but the very, very simple version of this is that the actus reus means you have to have an evil act, either an action or a lack of action that is illegal. Okay, you have to actually do something or not do something when you were supposed to do something in order for it to be a crime. And then you also need the mens rea, i.e. the mental component, i.e. you purposefully did that thing that you knew to be illegal, right? So if I kill somebody, if I shoot somebody, I have to have both the actus reus, i.e. me holding a gun, pulling the trigger, pointing it at the guy, and the bullet killing him. That is the actus reus, right? But I also have to have the mens rea, i.e. I knowingly and consciously held that gun, pulled the trigger, and it went off, right? So if I'm holding a gun, and this is a very rare thing, never actually use this as a defense in a court case because they will laugh you out of court. But let's say just totally theoretically, I'm holding a gun, my finger's not even on the trigger, and I happen to point it at somebody, and then it just goes off through no fault of mine. Maybe it's, high temperature something, or it's a faulty mechanical mechanism or whatever, and it shoots the person and kills them. I can't be held liable for that, because even though I had the actus reus, i.e. I was holding a gun and pointed it at a person, I didn't have the mens rea because I did not consciously intend to kill the person, right? And there's a difference between intending to kill them and intending to do the thing that ended up in them being dead. So I did not intend to fire the gun, even, right? Anyway, that gets real complicated and real quick. But there are some crimes where you don't need that mens rea. You don't need the purposefulness of either doing or not doing the thing that gets you busted. The classic example of that is paying your taxes. You don't need to consciously not pay your taxes to be criminally liable for not paying taxes, right? You don't need to say, oh, well, I know my taxes are due, I'm just not going to pay them. You don't need that. Just the fact that you didn't pay, no matter what your excuse, no matter what your mental capability or capacity was there, if you don't pay your taxes, that is a criminal offense. No mens rea needed, okay? There are also a few categories of inchoate offenses. Now, inchoate is just a really fancy way to say, basically, incomplete. So we wanted to commit a crime, but we didn't actually end up committing the full crime, okay? And in most jurisdictions, the penalty for the inchoate offense is the exact same as the penalty for the crime if you had been successful. So you don't get less of a punishment just because you failed, right? And there are three big categories of inchoate offenses. These are the most common ones. The first is conspiracy, okay? So if me and my wife get together and we start planning out a bank robbery, right? And we get, we draw a map and we have a plan together about, we're going to rob this bank and we're going to take the guard hostage and we're going to get money from the till and, all this stuff. And we plan it and we're ready to go. And we're actually doing this as not just a thought exercise, but actually planning to go and do it. That is conspiracy to commit, in this case, bank robbery, right? So the getting with other people and planning a crime in earnest is a crime in itself. You don't have to actually go out and rob the bank to be convicted of conspiracy to commit robbing a bank, okay? Second one is solicitation. The most common example, the go-to example here is prostitution, right? So if I go up to a woman and I say, hey, I will pay you $20 for this sexual act, that is a crime in itself. Solicitation of prostitution is the exact same crime as prostitution. Doesn't matter if the cops catch me before we actually perform the sexual act, right? Just the fact that I solicited and promised her money in exchange for that sexual act is the solicitation crime. It doesn't have to actually finish out with the whole prostitution thing, right? And then finally there's attempt, right? So attempted murder usually carries the same penalty as murder. So if I shoot at someone intending to kill them, but either I miss or the bullet hits them but they happen to live thanks to the great surgeons at the local hospital or something, I can still be tried and convicted of attempted murder even though the person didn't actually die. Okay? Does that make sense? These inchoate or incomplete offenses doesn't make them any less of a crime. They're still crimes even though you didn't finish the thing, whatever it was. Okay? Most crimes, or crimes that most people think of, are crimes against a certain person or a certain group. And we can rank these in order of seriousness in general. This is not a perfect list. There are going to be examples where you can say, well, one of these that's in the lower thing is actually worse than the one in the upper thing. But this is just, again, a general rule, okay? We tend to rank worst the crimes against the state, meaning things like treason and espionage and things like that, right? Those are like the worst of the worst. Underneath that, there's crimes against persons. Okay, this is where an actual person is the victim, and these are the classics: the murder, the rape, armed robbery, things like that, where there's some person that we victimized directly. Okay, underneath that, crimes against habitation, right? So burglary, arson of a household, things like that. Some crime against somebody's home, all right? Underneath that is crimes against property, right? So maybe burglary of a warehouse or vandalism of a structure or something like that. Beneath that are crimes against public order, meaning things that have a tendency to make things more confusing for the rest of us because we've all agreed to do things a certain way. This is like parking in the middle of a street, right? Or noise violations, right? Those are all public order crimes. And then finally, there's crimes against morality, which are the things that are wrong because we are just kind of morally icky against them, right? So like prostitution, drug use, gambling, those are the kind of the classic things. But there are some crimes where you could argue about which category they exist in. Again, this is just a general rule. But crimes have a tendency to be kind of ranked in seriousness based on this order. Okay? All right. I'm going to end it there. We're going to come back for section 4.2 in the next video. I will see you then.